So we are really excited about the next couple of hours in terms of the ability to bring in front of you some really thoughtful presentations and conversations about the role of copyright, and particularly in this digital landscape. Now, one of the things that we have said at every single conference, and I'm happy to say again, is that the policy decisions that get made in this town have so much more to do with the landscape facing the music community than people sometimes realize or understand. And it is our contention that the only way that the music community can fail to be effective in those policy conversations is if they refuse to engage. And right now, we are really thrilled to hear from two leaders who are working in different agencies, examining copyright, looking at where we are, where we need to go, and in particular, soliciting feedback from the public and from the community to get a sense of your feelings, your ideas, your thoughts, recommendations. First, we're going to hear from Shira Perlmutter, who is the Chief Policy Officer and the Director of International Affairs for the United States Patent and Trade Office. Recently, the USPTO released what's called a green paper that's shaped by public comments around IP and technology issues. And now USPTO is talking about this paper and soliciting feedback on specific areas that impact how musicians, songwriters, labels, and publishers, and really everybody who's involved in this industry, in this community, how they go about their business. So Shira is going to make a presentation about the work she's doing there. Then we're going to hear from Jacqueline Charlesworth, who's the General Counsel and Associate Registrar of Copyrights at the U.S. Copyright Office. Jacqueline and her team have been involved in a public conversation about the role of copyright, looking at how the 1976 law is keeping pace with today's technology. This has been subject of congressional hearings and kind of really gearing up the machinery to really take a look at where we are now, where we need to go. And so we'll hear from Jacqueline, then we'll have a dialogue with all of you. So it is my pleasure to turn the floor over to Shira.
Thank you, Michael. Is this working, the mic? Yeah. Well, it's really a pleasure to be here at the Future of Music Coalition, and also a pleasure to be able to appear with Jacqueline talking about the work that both of our offices are doing. As Michael said in his little pre-advertisement, on July 31st, the Department of Commerce issued this lovely document, which, as you can see, is indeed green. It's a paper called Copyright Policy, Creativity, and Innovation in the Digital Economy. And this was a long time in the making. To give you some idea of the background, it is the work product of something called the Internet Policy Task Force that was formed within the Department of Commerce, involving all of the different agencies with an interest in Internet policy that are located within DOC. It looked at 4 different work streams, including privacy, cybersecurity, something called free flow of information, and of course copyright, and this is the outcome of the copyright work stream. It began in 2010 when the IPTF was formed with some informal public listening sessions and then formal comment gathering. And then after 2010, to a large extent, the focus and the public attention shifted over to Congress, over to the Hill, where consideration was being given to dealing with internet piracy legislation, enforcement legislation, in the form of what eventually became Sopa and the Protect IP Act. As you know, at the beginning of 2012, those pieces of legislation were subject to a fairly spectacular attack and did not, and were essentially abandoned, at least for the present. At that point, in about the middle of 2012, we looked at comments that were submitted to the IP Enforcement Coordinator in conjunction with a strategic enforcement plan that she was working on. We looked at comments that were submitted to the Copyright Office in conjunction with a number of different issues that they were studying, and worked on getting this paper out. Now, there were, which we finally, as I said, were able to do this summer. The overall goal of this paper, from our perspective, was first of all to deliver a clear message on behalf of the Department of Commerce and the administration that these are very important issues, that copyright matters tremendously to our economy and to our cultural development, and it's incumbent on all of us to find solutions and to make it work appropriately in the internet environment. Second, we wanted to make quite clear our view that there's no inherent conflict between strong and effective copyright protection and a vibrant and innovative internet. And often people tend to discuss these issues as if there were an inherent conflict, and we believe there are appropriate compromises to be found that will allow both to thrive. And finally, and probably most importantly, these debates have become so contentious, especially in conjunction with the Sopa Protect IP Act public debate, that we thought it was very useful at this point in time to issue something that described the landscape, that gave an objective, calm framework for discussion and said, look, here's what copyright does, here are all the issues that are involved in the digital environment, here's the work that's been done so far to try to adapt copyright to that new environment and those new technologies, and here's what still remains to be done. So that's what the paper tries to do. We really are hoping that it helps set the groundwork, along with all the work that others are doing, for a more rational and constructive dialogue on many of these issues. So in terms of the coverage of the paper, it is specific just to the copyright issues involved in the internet environment. So there are a lot of other issues that affect all of you that we do not get into. And that's of course because it's part of this Internet Policy Task Force effort. We do not address some of the very new issues that might be emerging that weren't raised in any of the comments to the government. For example, things like 3D printing or big data. But otherwise, we do try to be quite comprehensive in our coverage, and we spend a lot of time on the international context as well, given the fact that the same issues are being debated elsewhere as well as here, given the fact that markets are now global, and given the fact that a lot of what can be done in this country is shaped by the framework of our international legal obligations. The international context is an important part of anyone's consideration of these issues. The paper is structured in two sections, which are deliberately designed to be of fairly equivalent focus and weight. One looks at how we maintain the balance of rights and exceptions as the law continues to adapt to new technologies, continues to be updated. The second looks at enforcement. Once we've achieved an appropriate balance for our time and place, how do we make sure that the rights that we've developed can continue to be meaningful in the online environment? And the third section looks at the online marketplace and licensing. And we think those are all key components to the future of copyright. So we come out with a number of recommendations. I note that the program talks about some of the issues we will discuss, including how we see the legislative environment, how we think government can best feed into what is happening in that environment. So I will just note that of all of the recommendations that are made in this paper, some are legislative, but certainly not all. And one of the points we've made is that we think finding solutions to the current challenges will entail a combination of techniques. And some of that will be legislative, some of it will be court decisions and interpretations, some of it will be regulatory, some of it will be voluntary initiatives, whether initiatives taken by individual companies or particular industry sectors or private individuals. But there are a lot of ways that we can move forward that may be easier and faster than legislation or may complement legislation. There's a big role, of course, for just what is done in the marketplace, and there's a big role for public education and awareness, an issue that people have been talking about for years but haven't yet done enough to address. So we are looking at a mixture of options, a mixture of solutions. Now, very specifically, what are the recommendations in the report? I won't go into a lot of detail, but just to give you a bit of an overview. In part one, which is dealing with the balance of exceptions, rights and exceptions as they are updated, that part, as you might expect, is primarily legislative in nature because we're talking about rights and exceptions. First of all, we renew a call that the administration has made several times and the Copyright Office has been making for a long time to create a broadcasting right in sound recordings. We also talk about the value of rationalizing the current divergent standards for rate setting for different kinds of online music services in the Copyright Act. So we don't take a particular position on how that should be done, but we do say it makes sense to rationalize overall the public performance right for sound recordings in all of these respects, taking into account not just the impact on the online services, but also the impact on creators, right holders, performers. Second category of issues, we support the work that's being done by the Copyright Office, looking at updating the exception for libraries in the Copyright Act to deal with new digital technologies, and the work that they're doing to look at orphan works, that is, works as to which it is not possible or extremely difficult to find the owner, perhaps because of their age, perhaps because of other circumstances. And as many of you know, the Copyright Office has recommended in the past an exception to the law, exception in copyright law to allow easier use of orphan works without fear of infringement penalties. And it is continuing to do that work, which hasn't yet been successful in passing in Congress. And then we also support the work they're doing on mass digitization, that is looking at the question of, even for works that are not orphan works, to the extent that there are large collections available in repositories like libraries, is there a need for or a possible option for an exception that might make it easier for people to digitize those collections. And I'm talking about exceptions, but I should note that the Copyright Office preferred approach the last time they looked at it was not an exception, but a limitation on damages, and that seems like an interesting approach as well. We then propose to take forward some processes seeking public comments on two additional issues, and one is the legal status of remixes or mashups. And the question is, there are a lot of remixes being created today and posted online, generally relying on either a YouTube content ID license or potentially fair use. And the question is there any need for greater certainty or clarity? Is there a need for other licensing mechanisms? Is there a need for a more specific exception in the Copyright Act? We're inviting people to give us comments on their views. The other issue is what's called the first sale doctrine, the law that allows you, when you buy a book, to give your book to a friend without needing the consent of the copyright owner. The Copyright Office looked at this issue in 2001, the question of whether that kind of doctrine should be extended into the digital environment when people transfer a digital copy to a friend that they've already purchased. And at that time, the office determined the answer was no. It did not make sense to extend the doctrine that way. We're not necessarily suggesting reopening that, but we are saying, let's look at what's happened since that time, since 2001. Are there any changes that should be taken into account? And more particularly, the question in our view is not, should the first sale doctrine apply or not in the digital environment? The question is, what was accomplished by the first sale doctrine in the analog world, and are there ways in which we can accomplish the same goals in the digital world, which might be through entirely different techniques, including marketplace offerings? And this is an issue that the Copyright Office has also expressed interest in looking at. And then finally, in that first part, we do urge that there be greater clarity in the application of fair use and support the work that the Copyright Office will be doing pursuant to a request by the IP Enforcement Coordinator to summarize fair use jurisprudence, summarize case law in a way that could be helpful to creators. In the second part, the one that deals with enforcement, this is an area where it's a mix of legislative and non-legislative solutions that we're looking at. In terms of legislation, again, we renew a call that's been made before by both the administration and the Copyright Office, and that is we have an anomaly in the law that when someone commits an act of criminal copyright infringement, an infringement that rises to the level of criminal conduct, the penalties available if the act consists of streaming to the public are lower than the felony penalties that are available if the act consists of illegal reproduction or distribution. And we think it makes sense, again, to rationalize those penalties, have the range of available penalties be the same, whether it's an act of streaming, reproduction, or distribution. Second, we're going to look at the issue of, and again, ask for public comments on and hold roundtables on the issue of the application of statutory damages in two very specific contexts. If you read the Green Paper, you will see that it affirms the importance of statutory damages for copyright owners and the importance of statutory damages as a deterrence for infringement. But we note, and especially in the online environment, but we note that there are two areas where questions have been raised about whether the application of the existing range of statutory damages, which are calculated on a per work basis, might be reconsidered. One is the area of infringement by individual file sharers, and the other is the question of secondary liability for online services that may be disseminating hundreds of thousands or millions of pieces of content. And so we are going to ask for we are asking for public comment, and we will be looking at what people have to say on those issues. The other area that we have announced a public process on has to do with the notice and takedown process under the DMCA, the Digital Millennium Copyright Act. This is the process by which copyright owners can provide notice of infringing content to internet service providers, and then the ISP will take that content down or block it. In the various comment processes that we held, that the IP Enforcement Coordinator's Office held, there were a number of complaints from all sides of the issue, from stakeholders who were users of the system, whether right holders or either users or would-be users of the system, whether right holders or ISPs, that there were various ways in which the system was becoming burdensome to operate, either because of volume, either because of abuse of the notice system or mistakes in notices, sometimes because the system is too difficult for individuals to use, and sometimes because of what you might call the notice and stay down problem, that content might be taken down and then immediately the same content would pop back up and require another notice. It seems to us that a lot of these issues could be dealt with without the need for legislation, without having to reopen the DMCA. And so we're suggesting a process whereby stakeholders would sit down together, talk through the issues, and see if they can help each other make the system's operation less burdensome. So we would like to look at that issue as well. And then there are a number of initiatives that have nothing to do with legislation that we support, that we think are a good idea. One is voluntary initiatives to try to address online infringement. There are a number of them that have come into play over the course of the last couple of years, several of them supported by, again, the IP Enforcement Coordinator's Office. We are engaged in the process of trying to determine how to assess the impact of these voluntary initiatives, and we've requested public comment on that issue as well, and the comments we've received are available on our website. We also are very supportive of the work the Copyright Office is doing in looking at alternative methods for enforcing small claims, short of having to go to court, and Jacqueline is the leading expert on this, so maybe she'll address that issue as well. And also, again, public education and outreach. And then finally, in the area of the online marketplace. In this area, we're talking primarily about things that don't have to do with legislation. We acknowledge that building the online marketplace is primarily a function of the private sector. And in the report, we talk about the tremendous and exciting strides that have been made in bringing content to consumers in many, many different formats in the online environment. Just over the last 5 years, in fact, there's really been an amazing explosion of available content. But we do say there is still room for improvement. There is more that can be done in terms of having widely accessible rights ownership information, in terms of ensuring the interoperability across sectors and across borders of databases and licensing platforms. And one of the questions we have is that we're asking for public comment on is what can be or should be the role of the government in trying to help facilitate the online marketplace. Some of what's being done, again, is being done in the Copyright Office through work on their registration and recordation process, among other things, but are there other steps that we can take as well? And we look forward to hearing from all of you on that. So just to conclude, we have a request for public comment out, and we're about to issue another one updating the dates a bit. We originally planned to have a kickoff full-day conference on October 30th, but unfortunately, because of complications arising from the 2-week government shutdown, we've had to postpone that. It's now scheduled for December 12th. Written pre-meeting comments are due November 13th, and then there will be an opportunity for post-meeting comments as well. Submitting comments is not a prerequisite to participating in the conference, and we welcome everyone's participation. And we will be, after the conference, looking at all of the public input we receive and determining how best to take all of these issues that we've identified for further work within the Department of Commerce, how to take them forward, which will probably include a series of roundtables in different parts of the country. We do see, in terms of the ongoing copyright review that's taking place in the House and the work that the Copyright Office has recommended, starting with the Register of Copyrights speech on the next great Copyright Act in this last spring, we see that there's a lot of overlap between these processes, although we're looking at some slightly different issues, and we're only looking at the online issues, and obviously not just the legislative front. But what we're hoping is that we can provide some factual input to any congressional or Copyright Office process, and then be able to provide some views and recommendations from the administration and from the Department of Commerce. And of course, we're looking forward to working very closely with the Copyright Office and with the Hill as well. So we welcome all of you to participate and hope we will hear from you as we all try to see how we can make progress on these difficult issues.
Thank you, Shira, and to Shira and everyone else. I'm sorry, I have a terrible cold, if that wasn't clear. So I apologize for that in advance. It's always a pleasure to address the music crowd. I came to copyright through my experience in the music industry, and it's really there that I developed my love for copyright and my interest in all these issues, working with songwriters and artists. So I'm grateful to be here today and thank FMC for inviting me. And you know, as Shira alluded to, and I want to echo, your input into public policy is critical. And I think some of the research that you guys saw, I think earlier this morning, some of the insights that you have as actual working musicians are very important for Congress and agencies to understand as we think about policy issues. So I do encourage you to participate in the process. Turning to some of the issues, I mean, Shira did a really great job of summarizing a lot of the work that we're doing in government, including some of the Copyright Office initiatives. I thought, looking at the program announcement, it refers to outre actions of government. And I have to say, I think I've always wanted to be a little outre, but sadly, I'm just a government lawyer. So I looked up the word. It means highly unconventional, eccentric, or bizarre. Perhaps. Our reports would have to get a little racier, I think, from the Copyright Office to meet that standard. But I thought I would keep things a little bit racy. I don't know why. I was in sort of a philosophical mood when I was thinking about addressing you, and I thought, well, why not just dive right into where a lot of the controversy is and speak a little bit about copyright in the First Amendment. Now, many see copyright as fundamentally in tension with the First Amendment, and I don't agree with that, but there is very good reason to be vigilant about our First Amendment rights and how they interact with copyright. There are two very important sort of protections built into the copyright system to protect the First Amendment. One is the idea-expression dichotomy. You may have heard of that. What that means is copyright only protects the expression of an artist or an author. It doesn't protect the idea, so people are free to take that idea and discuss it and portray it in different ways in the future. And the other area, which I'm sure I would imagine all of you have heard about and thought about, is the fair use doctrine, which is often referred to as some breathing room. It allows people to take even copyrighted expression in limited ways where there's a good reason to use it for comment and criticism and reuse it. Shira talked about remixes, there's parody. There are many ways in which we want to borrow other people's expression and comment on them. And it's very important to maintain the vitality of both those doctrines in our law. But the area that I really actually wanted to address is more fundamental, and that is really how copyright, in fact, serves the First Amendment. I think it's fair to say I'm not sure we would have much of a First Amendment without copyright. And why is this? Because without copyright, authors would need to rely on the good graces of either government or patrons to do what they do. And if you think about that, that's not a very good formula for free speech. In other words, if you're beholden to either a noble patron or a government to fund what you're doing as an artist, I think that is a very concerning idea. And in fact, the framers of our Constitution agreed. Those who founded this country, the first Copyright Act was passed right around the same time as the Bill of Rights, right? So they saw them as very compatible, and there's a lot of early writing that talks about the importance of giving authors the ability to market their works. To quote the Supreme Court, in a 1985 case, the framers intended copyright itself to be the engine of free expression. By establishing a marketable right to the use of one's expression, copyright supplies the economic incentive to create and disseminate ideas. So far from being inconsistent with the First Amendment, the founders of our country viewed the marketable right created by copyright, which allows for the independence of authors, as essential to freedom of the press and the advancement of knowledge. And I think, particularly as many of you are artists and authors out there, I think that's a core issue. You create something, and at least to begin with, it's yours, and you can decide what to do with it. You can decide to give it away. You can decide to assign the right. You can decide to sell it. You can decide to license it. And we take that for granted in some sense, but we really shouldn't. That was actually not always the case. And so here we are 200 years later. We still have a situation where we're not dependent happily on government or patrons necessarily to create art, but I think the marketable rights to one's work are in a state of flux, and particularly in music. I think perhaps in no other area than in the music area have we seen such a change. And Shira, of course, spoke about the internet and how that's changed people's habits. But I think in reviewing our copyright laws, and Congress is now doing that, we need to be very thoughtful and make sure that authors still do have the independence they need to eke out a living or make their way by practicing their craft. I know that many of you are working hard to make lives as musicians in this changed universe. And as I said earlier, I see that in some of the impressive research that's been done by FMC. And I just want to say, I think copyright law needs to make that possible. So then you get into questions of how. And Shira really did do a great job of talking to you about some of the particular issues that that we're grappling with, whether it's enforcement or how you define authors' rights in the internet era. As many of you know, last spring, following a call for updates to the law, the copyright law, by the Register of Copyrights, Maria Palante, Congress embarked upon this process of review. And so far, they've held several hearings that I would describe as fairly high level, sort of, again, somewhat philosophical, big picture items. And what Chairman Goodlatte has said is he's going to go on and look at more specific issues as time goes on. The last general revision of our copyright law, and although there have been some intervening amendments, but the last general review and revision was in 1976, and it took over 2 decades to pass that law, to study and pass that law. And when it was done, the former Register of Copyrights, Barbara Ringer, who had worked closely with Congress during that process, called the 1976 Act a good 1950 copyright law. So that gives you an idea of, there's just inherent, perhaps, lag, if you will. It takes a long time to get things through the legislative process, but, we're dealing with a law that, I don't know, I keep thinking about like Happy Days and jukeboxes, and that's not what the world is today. We need not a 1950 copyright law to govern music in the internet age. And, again, music in particular, I think, stands out as an area where there are many pieces of it that I think require some updated thinking. We need to consider the individual artists who want to make a living writing or performing music, or both, and how to enable them to do that. We need to consider the role of intermediaries, both the old ones and the new ones. There are the traditional intermediaries, the record labels, the publishers, movie studios, and then you have the new intermediaries who distribute your work, the technology platforms. And under the traditional model, artists assign their right or chose to sign with a label or a publisher, and then often receive an advance to support their work. So there was a way to support an artist while they were developing new material. That's not really true with the new platforms, right? You put your work out there and then you see if it attracts eyeballs and maybe some ad revenues. And I think that's a very big shift, and it makes it difficult to be a musician today. I give a lot of credit to people. I think you still have to have a great deal of passion to pursue that career, particularly under today's conditions. I see headlines like it takes 5.2 million streams to earn minimum wage, and obviously that's something that some very few people achieve, and that's a wonderful thing. But it's not necessarily, it is not the norm, and I think it needs to be possible to be an artist, an author, a musician, without that kind of extraordinary success. We need people to be able to make their living in the arts based on their marketable right in their works that they create. So in addition, I think specific to music, we really have to think about our licensing structures and issues of platform parity. We're dealing with an over 100-year-old, it's not even 1950s, it's 1909, the license for musical compositions, the statutory license. It was, I told the story before, I went and looked at the original 1909 license, what is now Section 115, and some of the words are exactly the same. It's amazing. And we don't really deal in a world of song-by-song licensing. We deal in a world where internet services need to get up and running with millions of songs. And so that's something that I think there was some interest in looking at that a few years ago. I suspect that that's something we'll be looking at again, is the Section 115 license, and some of you may have some thoughts about that, whether it should be changed to a blanket license. We also have, and Shira alluded to this, we have different government rate setting standards for musical works and sound recordings depending on the context, and different ways that the Copyright Royalty Board evaluates what should be paid to artists and songwriters for the use of use of their works. And I think that's another area where we could be examining or thinking more about, what makes sense. I mean, should we be preferring some platforms over others, or should copyright law be more neutral? And when it comes to the technology, which is always changing. I think another area, I think it's fair to say that we have very messed up metadata in the music industry. Yes, very. And it's one of those things where, I mean, I've worked at Harry Fox years ago, and like the lawyer part says, oh, well, you just design this, and you just do that, and you just create a grid, and here are the things, and it sounds so easy, but it's so hard to get everyone on the same page, and it really gums up the system. It makes the administrative piece of music licensing so expensive and so out of proportion to this very, unfortunately, relatively small revenues that are coming, say, out of streaming models. And so I know your organization, many organizations are looking at this. Hopefully government can play a role to help that. And then Shira alluded to the fact we still don't have a public performance right for sound recordings on terrestrial radio, which is something the Copyright Office has supported for a long time. We have issues of enforcement. I recently was very involved in the Copyright Office study of the issue. I mean, basically, federal court is just too expensive for most people. And so if you have like a modest-sized copyright claim, someone's infringing your work, I think the statistic was for a claim of under $1 million, the average cost is $350,000 to bring a suit in federal court. Well, I mean, it goes without saying that, no one, regular people can't access the courts to enforce their rights. So we took in a lot of information from stakeholders. We looked at the law and have proposed a voluntary system that would be less expensive, where copyright owners and users could come to resolve smaller copyright disputes through a government-sponsored process. And it's a very interesting study. I hope you'll take a look at it. It's on our website, and it may be something you'd be interested in following, because at some point you may actually have a copyright dispute that you want to address. And I think the last thing we have to think about is the public and the fans of your music. Consumers are now the copiers, and they interact with copyright law on a daily basis. And the question there really is, can they be persuaded to respect copyright and the marketable right in your work? And I think that that is something we all need to work toward, including government agencies, including the Internet Task Force, and including you guys out there. So these are some of the issues that will be before Congress, that will be in the air, that people will be discussing. I don't think they're outre. I think they're pretty fundamental to moving forward and updating our law. If you're interested in getting involved and seeing what the Copyright Office is up to, please visit our website, which is, yes, was restored after the government shutdown, www.copyright.gov. And if you go up there and look, I think it's under a publications tab, but there's a way to sign up for our Newsnet service. And we don't inundate you, but once or twice a week you'll get a notice. We have a rulemaking proceeding. There's a public hearing on something. There's a report that's been issued. It's a very good way to sort of stay up to date on the big things that are happening with the Copyright Office. So I encourage you to sign up for that. We want to hear from you. Thank you.
Thank you so much. So I think what we're going to do, are they ready to go? Can we do 2 questions, or are they ready to walk out? 100% ready. So we're going to do like 2 questions. I want to just flag a couple things. Thank you so much for both of your presentations. The FMC Twitter feed, we'll put out links to the proceedings that you're involved with, so just you can get the links off of our Twitter. And I really want to just really emphasize one point that I think both of you made really well, which is that I think sometimes people in the music community feel like there are barriers between them and the policy process because they may lack specific expertise. They may feel like they need to be able to come in and have the solution, quote unquote, or they have to be able to speak to very detailed or highly technical aspects of the law. What policymakers need to hear is they need to hear, what is your experience? They need to hear, how are you making a living? What are you worried about? What are you excited about? What technologies are working? What business structures are working? You need to go to Capitol Hill. You need to speak with your congressional representatives. They want this thing to work. And it's their job to figure out how to take the reality of your experience and put it into a policy context that works. So don't feel like you have these barriers of lack of, if you don't understand, if you're not a copyright lawyer, or if you don't feel like you have a solution, don't let that be a barrier to being involved in the process and engaging in these dialogues. It's really, really important. We're going to do 2 super fast questions because we're like 2 hours into the conference and we're late already. I love it. Go ahead. I'll go first.
Yeah, Charlie Sanders. I'm counsel to the Songwriters Guild of America. I just want to thank the Copyright Office for its interest in the small claims issue. A right without a remedy is no right at all, and creators in this country are being crushed under the weight of piracy and all of the accompanying horrors that go with it as the corporate interests swing their chunks at one another, and the creators get no relief at all. So I think it's a tremendous step forward if we give individual creators, who are the people that Article 1, Section 8 seeks to benefit through the Copyright Act, the right to enforce their copyrights.
Thank you.
Hi, Debbie Newman. I have a quick question. Unless I missed it, your list of agenda items that you're looking at with copyright law, I'm curious as to where this whole issue of pre-72 recordings falls with the lawsuits that are currently in process and the debate over whether or not state law, California state law, whatever, New York state law, covers for the sound recordings, the exploitation of those sound recordings on digital music services, for example.
Thank you. Yes, for those of you who don't know, sound recordings, federal copyright protection for sound recordings under the law is from 1972 forward, and so we obviously have sound recordings that predate that. And increasingly, or recently, there have been a number of lawsuits revolving around the fact that, for example, streaming uses and other uses of pre-72 works are infringing or potentially infringing. I think it was in 2011, the Copyright Office actually did an extensive study of this issue. We recommended in that study that the pre-72 works be federalized. I think there's a lot of, just on a practical level, having a unified system for sound recordings just makes sense, right? Especially in the digital realm where, again, you want to license everything, and so there's a logic to it. I think given those lawsuits, there may be a renewed interest in this issue. The question is whether the players, the RIAA obviously has concerns in this area and so forth, and whether, their thinking has been updated in light of some of the issues that have come up in these lawsuits. So I have a feeling we're going to be seeing and hearing more about that issue, and that report will be dusted off a little bit, and people will be reading it or rereading it and thinking about the question of whether we should just bring all sound recordings into the federal protection.
Thanks.
Jacqueline, Shira, thank you so much for joining us this morning. And I'm going to bring out Casey Ray and the group who's going to make the next presentation.